Welcome, a short video about the importance of the role of victim in front of the International Criminal Court.
Why victims want to participate at trial? Which are the expectations of victims at the start of a trial? When I think about justice, I mean that I want the truth about the events I suffered from, and like me, many others in Uganda. We want the truth to be established so that we may be satisfied. I want the court to work well with one heart and this case to end in a just manner. I trust the court to dispense justice for us survivors.
I am 69 years old. When the LRA attacked the camp, 3 of my children were killed. I was severely beaten, and 80 of my cows were taken. For this reason, I want my voice to be heard before the court. The court should know that I need justice and reparations for my children who were killed. My mother, my brother, and my sister were killed at the time of the attack. At the time, I was attending school. I wanted to study to assist my country, but I had to stop my studies because of the war. Since my mother was killed, I had to take care of the family. The court should know what really happened to the people here in northern Uganda, so that the judges will be able to make a just judgment, and if the perpetrator is guilty, then compensation to the victims could be paid. It cannot be impunity. Nobody is above the law.
My husband was abducted and killed. My house was burned and my property looted. I have problems in paying school fees for my children and in providing them with proper food. We need assistance. In my thinking, the court should make some reparations for us. If justice is done, this will help in avoiding other crimes to be committed again. The sufferings I went through were enormous. Life is hard now. I was abducted as a young girl and forced to become a rebel's wife. When I was back from the bush, I found out that my parents were dead. Every time I mention what happened to me, I feel the trauma and the bad images come back. Even now, I have difficulties with my children in the community. I wish I could live for another place so that I can live in peace with my children. Here, I'm stigmatized because people do not completely forgive us and keep pointing out at us as the ones who are in the LRA. The sufferings I went through can never be compensated, but the court should make us feel that justice is done, so that we can live knowing that justice exists.
When the LRA attacked the camp, I was 7. They took my uncle, who was taking care of me, and he never returned. So I have been left alone. I think that the court should help us in reconstructing our lives.
Victims have been waiting for these proceedings to start for 11 years. They hope to contribute to the search for the truth about the events at the origin of their victimization and to have their voice heard throughout the proceedings. They expect an independent, impartial, transparent, and efficient justice, capable of addressing their sufferings.
So let me introduce you our guests, Professor Michele Caianiello from Bologna University and Dr. Paolina Massidda from the Office of Public Counsel for Victims at the International Criminal Court. First of all, let me thank you for joining us in this relevant session. I remind you, given the sensitivity of the moment in relation to the international crisis in place, that the International Criminal Court was founded in 1998 with the Rome Statute and is competent to judge those responsible for international crimes, genocide, crimes against humanity, war crimes, and the crime of aggression. I'll take you just a second to notice you, our watchers, that in a parallel channel of the festival, a live session about la difesa dei diritti nel mondo, in pericolo l'incolumità degli avvocati, led by Ordine degli Avvocati di Modena with the International Observatory of Lawyers at Risk is ongoing. All the festival session will be recorded and available on festival's YouTube channel on its website. If you agree, I start with Professor Caianiello, who will moderate the panel. Professor Caianiello, the floor is yours.
Thank you very much. First of all, let me thank all the persons, my friend Luca Luparia, the institutions of the university, first of all, the University of Modena and Reggio Emilia, the other institutions like the Penal Chamber of the Italian country, the local Penal Chamber of Modena, and all the institutions that supported, participated, took a step in this wonderful festival of the criminal justice. Good afternoon to everyone. I'm happy to be here, and I'm honored to stay together with Counsel, Mrs. Paolina Massidda, who is with me. So I have the burden and the honor to introduce the issue, to ask a question. We are dealing with the topic of victims' efforts in searching for the truth. And this is already a problematic topic because my first question could be about what kind of truth, if a criminal proceeding and a polarized criminal proceeding between a prosecution and a defense is an appropriate venue for searching the truth for victims, or should another kind of institution or venue or mechanism more appropriate to pursue this task? But first of all, I would like to ask some questions, if it's possible, about our background, and in particular to Paolina Massidda, if you agree.
Certainly, thank you.
So I've seen various videos concerning your history and how you started to deal with criminal justice, with the international dimension of criminal justice. So I was wondering, because I started in a very unpredictable way. I wanted to follow another path of research, but my mentor told me that you have to study the topic of the International Criminal Tribunal for the former Yugoslavia, and we were in the mid of the 90s, and so I had also to study the project to building up an International Criminal Court, and then I never stopped since then. But I was wondering, which were your path to arrive to here, to represent victims before the International Criminal Court?
Thank you, Professor. Before I answer this question, I would like also to thank all the organizers, in particular my good friend Luca Luparia. We spoke about this panel some years ago, and I'm really happy that finally we could have this panel. As far as I am concerned, I am an Italian lawyer. I have been practicing criminal law in Italy for 12 years. And then, of course, I had already in Italy a certain passion for international criminal law. I decided to follow at the university a diploma on international humanitarian law at the University of Geneva, which at my time was not so peculiar to do. And I started, therefore, with international criminal law, human rights law, and at a certain point in my life, while I was doing my job as a lawyer in Italy, I followed several cases before the European Court of Human Rights first, and then I decided to go for 2 months at the International Tribunal for the former Yugoslavia during the summer holidays, just to have an idea of what was in practice this international criminal law. And I have to say that from that experience, I was immediately offered a position in chambers at the ICTY, which I took for several months in parallel with my job in Italy. And then once the International Criminal Court was created, this Office of Public Counsel for Victims was created. And I thought, well, maybe it's something for me. I love pleading in an international setting. I am particularly empathic with victims. And I proposed my candidature for that position. And I got that position in 2005. Thinking of remaining in The Hague practically only for 2 or 3 years, and it's now 15 years that I am the principal counsel of the office.
This is great. It's not usual to find, especially in our country, in Italy, a criminal counsel, so much into international criminal justice. Because it's uncommon. So my compliments and congratulations for your choice. And now let's get back, if I can, to some more technical question. The first concerns the shape of the trial before the Criminal Court and the attendance of the victims. Because if I get it right, you are representing victims. So my first challenge is, do you think it is necessary for victims having a dedicated counsel for them? Don't you think, for example, like in other countries, that the prosecutor could provide to represent all of them? After all, he represents the part who suffered the damages, the injuries coming from the crime. Well, there are other countries, like Italy, for example, where victims can be represented autonomously. But this is not a neutral choice. So, in your experience, do you think that was it a good solution to select or decide to have victims properly represented, or do you think that this makes the things more complicated?
But absolutely, with no hesitation, the answer is yes. It was a good choice from the drafters of the Rome Statute to provide the possibility for victims to have a role in the international criminal proceedings for several reasons. Of course, sadly, to some extent, the International Criminal Court exists because you have victims everywhere. So the response is to try to find justice for victims, and this should be, and it is, the mandate of the ICC. Now, if we look more in detail at what is feasible and possible for victims before the ICC, we can easily understand that this exercise of having victims involved in the criminal proceeding was an exercise of balancing the different position of different parties in the proceedings. On one side, the prosecutor, on the other side, the defense, and we could say in the middle, a new actor in international criminal proceeding, which was known until the entry into force of the Rome Statute in 2002. And why it is important, in my opinion, that victims have been given this role in international criminal law. But essentially because it's the chance for victims of making their voices heard independently from the office of the prosecutor. Professor, you rightly indicated to some extent the prosecutor is also doing the interest of the victims in prosecuting the persons who is supposed to be the perpetrator of the crimes. But the way in which the prosecutor decides to investigate and prosecute may be with different interest if compared with the interest of the victims. Give an example to explain what is my thinking. Normally, particularly at the international level, the prosecutor tends to have narrow prosecution, tend to narrow the extent of the charges and the extent of the crime. And this is certainly not in the interest of the victims, considering the vast victimization suffered by victims when we are talking of international crime. So the interest of a victim is, for instance, to make their voices heard, so that, for instance, investigation and prosecution are broadened. But even when we are in a case, the voice of victims is important, first of all, because they are the only one able to make the judges and the public understand what happened. In reference to the cultural background, the historical background, they are the only one able to explain the extent of a victimization. And this component is very important. It is not only very important for the search for the truth, since the panel is also about the search of the truth, but it's also very important, a sort of a cathartic effect for the victims that allow victims to try to turn the page after all the suffering and after all the harms that they suffer from.
So if I may sort of comment your answer, we could say that there are at least two kinds of truth. The prosecutor is the one that can be proved beyond reasonable doubt.
Yes.
Prosecutor has this burden, and if this burden is not fulfilled, she may lose the case and the defendant can get acquitted. So in certain cases, perhaps it's better to narrow the charge and to focus on just what you can prove beyond reasonable doubt, and discharge all the other things because they are troublesome. But for victims, it's not the same. That this is what you are saying, that sometimes it's important to tell a story even if...
For victims, it's important, I think, two things. First of all, the possibility of being heard and to tell the story the way in which they want to tell the story. If victims only appear as witnesses for the prosecution, for the defense, for the counsel for victims, they will be confined to the questions posed to them. This is not necessarily the total story that a victim wants to tell and want to be heard. So this is important for the victims to really explain what happened to him or her. But second, it's important also for the victim to search the truth. And actually, when victims are asked, why do you want to participate before the International Criminal Court, the first thing that comes to their mind is because I want the truth of what happened to me. So in certain sense, the search for the truth is the same, if I can put that way, that the prosecution is pursuing. Simply, the victims are pursuing the same interest in a different way. They may be willing to plead a different mode of liability, for instance, or they may be willing to have a more focus on the type of victimization that they suffer from. And of course, and in this they differ certainly from the interest of the prosecutor, they want a large number of crimes to be prosecuted. And I agree with you, Professor, this is in international settings sometimes is very difficult because you have a very complicated issue in collecting evidence, the possibility to access or not access to certain regions of the world where crimes are committed, which are not necessarily safe and which are far from where the prosecution is ongoing, and with logistical difficulties on top of everything. So victims understand that not all the crimes can be prosecuted before the ICC, and that not all possible perpetrators can stand trial before the ICC, but still they have an interest to see their victimization recognized and the full extent of their victimization.
So, in a certain way, the most important part for representing the victim is giving them a chance to tell their story, if I get it right. Because
Yes.
when you study, I'm an academic, so I have no experience about how the proceeding works in practice. Well, I sometimes I wonder why I'm speaking about something I don't know in practice, but let's leave it apart. The problem is that if you read the papers, that is the statute and the rules of procedure and evidence, there are various stages in which victims' representative may be heard. Even at the beginning of the proceeding, to initiate a case or to open a situation, for example, even in that case, there is some standing for the victims. But of course, there is the trial. When you interpret your role as a counsel, what is the main important step, do you think, the main important stage? Or everything is important? I don't know.
No, I think that what I consider as a lawyer for victims a very important stage is what we call the preliminary examination. The preliminary examination is very sensitive for victims. The preliminary examination is not really a stage of a proceeding, is the phase in which the prosecutor collects information in order to decide whether or not to open an investigation. Now, why I'm saying that this is very sensitive and important for victims? Because at that point in time, via the provision of information to the office of a prosecutor, the victims will have a possibility to actually influence the extent of investigation. So as a lawyer, I think this is a very important phase in which victims and lawyers for victims should be included. Examples. It is possible for lawyers to provide already at the stage of a preliminary examination to the prosecution memorandum about the type of crimes committed, the qualification, the legal qualification, information about the chain of command, information about potential witnesses. This it's very important, and it's the chance for victims to actually influence to some extent the future prosecution case or cases. That said, the other main role that victims can play, in my point of view, is a trial. So once the pretrial chamber has decided that there are enough evidence to put the suspect on trial, then the trial phase is certainly the major one for the victims, because they will have the possibility to present evidence. This is normally not possible at the pretrial phase. It is possible at the trial phase. So victims will be able to supplement to some extent the evidence presented by the prosecutor. For the public, the victims cannot duplicate the evidence presented by the prosecutor. There is this exercise of balancing the right of the victims with the right of the defense and the right of the prosecutor. So victims have, let's say, a narrow role compared with the office of a prosecutor, but still they can present evidence. So this is also a very important step, because it will be, again, the chance for victims to eventually show something differently from how the prosecutor can picture or can explain what happened and the evidence available to him or her. And finally, the last phase, which is also very important for victims, it's the reparation phase, in which lawyers for victims are highly implicated. And importantly to note, the reparation phase is the only phase in which victims are full part in the proceedings. In the reparation before the ICC, the prosecution is not anymore a party. The parties are the defense and the victims. And why it's important? Because at that point in time, victims will need to prove their claims. So they will need to present evidence about the harms and the prejudice that they suffer. And that phase is only available to them if the accused is convicted, if someone is declared guilty after the trial. So I would say these are the three main interaction of victims with the court, and therefore the main task of a lawyer. If you allow, Professor, I would like to give maybe some more practical explanation, because this is the explanation in theory. But how does it really work? I think this could be interesting. First of all, victims can manifest themselves at any stage of the proceedings. They can appear at pre-trial, at trial, at appeal, only at reparation. Now, in order for them to be able to manifest themselves, they have to complete an application form in writing where they have summarily to explain what happened to them. Then there is a decision of the judges, and they are called then participating victims, someone who is really participating in the proceedings. Now, the role of a lawyer, once someone has been authorized to participate, is particularly complex, because the lawyer will be necessarily located in the Netherlands, in The Hague, where the court sits. But the victims will not be located at all in the Netherlands. The victims are located in the situation country, could be Uganda, Democratic Republic of the Congo, Philippines, Colombia, whatever. But victims of a case which concern, for instance, crimes committed in Sudan, in the Darfur region, they may reside in Sudan, but they also can reside in other countries. In a case which is now at the pre-trial phase before the ICC, we have victims coming from 17 different countries. Now, for a lawyer to be able to interact with victims, this is the main challenge. Because you cannot simply represent someone without knowing the story of that person, without knowing the background, without meeting with that person. Victims, as any other client, give instruction to the lawyer. You create a trust relationship with them, and this trust relationship is created via regular meeting in the field. So the most challenging part for a lawyer representing victims is to be able to meet with the clients and to fully understand what happened to them in order to be able to convey their story to the judges.
So you're meaning that you go to meet them where they live.
Yes.
Do I get it right?
That's correct.
You are going
if you are not in court, you travel. You are a frequent flyer. And also a frequent walker sometimes, because you can access some part of the region only by foot, sometimes only by car. So yeah, you get it right. You just travel to the location. Now, there are several security implications. Sometimes it's not possible to meet with the victims in the place where they reside, because on not rare occasion, victims still reside in place where conflicts are ongoing, where other perpetrators are living. So it can be that it's not so safe for the victims to see a lawyer, particularly if that lawyer is not from that region, at their house. So we normally have ways of transporting victims to a safer place where they can meet with a lawyer, taking into account, of course, the distance and the possibility for victims to move, of course.
But unless there are other reasons to avoid it, you tend to meet them and to know them personally.
Yes. This is, I think, it's the essential part of our job. I mean, when I say our, I mean the job of a counsel for victims, which in the system of a court is called legal representative of victims. It's the essential part for two reasons. Understand what happened and taking instruction. As any other lawyer, we need to take instruction from our clients. So we need to explain to them what happened in the proceedings, which are the issue at stake. On several occasions, victims tell to us which kind of questions they would like to pose to the witnesses. So it's really a relationship of exchange of information, and there is a lot of communication. Sometimes we need to find creative ways of communicating. In some countries it's relatively easy. I have quite a number of clients in Ivory Coast, and I regularly WhatsApp with them. In other countries like Uganda, I'm represented a little bit, almost 2,000 people. Out of this, only 125 have a phone. So you can imagine why I'm saying that it's challenging, because you have to adapt to the situation of each one, and you cannot leave behind anybody.
And in which language do you speak with them? Because I know you speak various languages, but maybe complicated.
Not all the languages of the world. Yes, it depends a lot of the situation. We have in Ivory Coast, for instance, everybody speaks French, so it's easy communication. In other situation, it's more complicated. People speak local languages, and this is another challenge. So we do not normally go with an interpreter. We prefer to have included in the team of lawyers representing victims based in The Hague, a co-counsel who is based in the field, someone from the region, from the situation country, who knows the background, the language, who is available 24/7 on call, and that victims trust. And this way of having people based in The Hague and based in the situation country, in my view, represent probably the most efficient way of legal representation of victims so far before the ICC. Now, of course, the fact that you have someone in the field does not mean that the counsel in The Hague does not travel. Actually, the counsel from The Hague has to travel because, again, I repeat, this is the only way that we have to fully comprehend the story and the victimization, the country, the culture, what is important for our clients.
And this is what I wanted to ask you, the main question. So tell us something, please, about the decision to let them speak before the court, the decision you have to make. If you think that sometimes that they have to behave in a certain way, but they want to tell another story, I'm not saying that. I'm just saying that perhaps something is important for victims that is not so relevant for the legal matter, but nonetheless they want to tell it because perhaps it's more important that. But I'm just guessing. Tell us what are the main thoughts about this.
But I think that it's important to understand first that victims can appear before the court as witnesses, so they can take the oath. And of course, what they will say can be used in the judgment. But victims have also another avenue, and it's the possibility to appear before the chamber simply telling their story without taking the oath. Now, of course, this part of the story cannot be considered evidence, and it will not be used in the judgment. It could be used eventually to corroborate other information in the case record. In the practice so far, normally there is a discussion between several victims and the lawyer to understand if they want to appear and why they want to appear. And then normally the counsel for victims help the victims in telling the story. For instance, the lawyer can just give a general question to a person so that the person is free to express. Now, in my experience, what victims really want is, first of all, to tell a little bit of the event. I was in my house, suddenly I heard something, I started fearing something, someone entered in my house, and they took my husband was killed, I was raped, everything was pillaged. So first they concentrate on the event, but what is also amazing when they start then continuing the story is the way in which they convey what happened to them as a person. So you can hear things like, I don't feel anymore a human being. I have lost my dignity as a woman because I was raped several times or because I was gang raped. I cannot anymore cry because I cried too much. I have no more possibility to cry. So this kind also of the recollection of the impact, which I think it's important in telling the story. It's not only telling the story for telling the story, but it's also telling what was the impact and what is still the impact of the events. And I think this is very important, not only for the victims, but also, for instance, for the judges, because this will help them to fully understand the context. Judges before the ICC are normally stay in The Hague. Sometimes it happens that they go for a short visit in the country, but they do not fully understand 100% the country. They are not from the country where the crimes are committed. So this kind of interaction, I think, is particularly important, not only for the victims, but also for the judges and for the public at large, which is then able to put some faces with the crimes committed, always help to fully understand the extent of the crimes, I would say.
Do you think that, I have one small question and then a big question, but the small question concerns, of course, as an academic, I wrote an answer to the small question, because I was able to write about big issues. But regarding the small one, do you think that the ICC could celebrate more part of the proceeding on site, that is in the place where the part happened?
Well, so far in all the cases in which I was appointed as lawyer for victims, I have advocated for a trial in situ, or at least part of a trial. For instance, when a trial starts, we have these opening statements. All the parties and participants explain what is their strategy, what they want to prove, and so on and so far. This could be done in the country, or the closing of a trial. Now, for various security reasons, so far it didn't happen, but in the ongoing case, which is a case related to the Lord Resistance Army, one of the commander of the Lord Resistance Army in Uganda, it was possible for the judge to spend 1 week in Uganda visiting the places where the crimes were committed. And I think that was very helpful, because one thing is sitting in courtroom, listening to a witness saying to you, I was on the top of the hill and I could see. And another thing is you being on the top of the hill as a judge and see exactly what you can see and remember what the witness told to you, but also see the way in which people live there, the way in which people greet you. These are very important part of the proceedings. And I would also like to add, what is very important is to fully understand the culture of the country where the crimes are committed. And I would like to give a small example. Again, in the ongoing case, practically all the witnesses coming were confronted with a question, had a very similar attitude, which was simply to bend and to look at the floor. Now, if you do something like that in a Western environment, it could be suspicious. It could be considered like, the witness is uncertain, maybe is not comfortable, maybe is lying somewhere. At the end of a prosecution case, I was the lawyer in that case for victims. I decided to call an expert on Acholi culture. And the expert on Acholi culture explained that this is actually a sign of respect. So the person will not confront you in your eyes because the person was questioned by someone who was more educated than him or her. It was in an environment which was particularly, to some extent, intimidating. It's a little bit assertive, the courtroom before the ICC. So the person was actually respecting the judges and the lawyer questioning them. But if you don't know that, you may infer something from the attitude, which is actually the opposite of what the behavior of a witness will show.
Thank you. Thank you. I have one last question that is a big question. So I apologize for asking this, but I think that the people who will listen to you and to us may be happy about a small remark. But what do you think means reparation for victims? You're coming from an Italian town, Genova, where we had torture in 2001, but we didn't have a legal word to define that behavior.
Yes.
And the European Court of Human Rights convicted Italy because we did not have the word, the specific word to name that behavior. So what do you think means reparation?
Well, this is a very interesting question, and there is a lot of debate about that. I would start with a data, which I think it's interesting. A few years ago, the office decided to have a sort of survey interviewing victims that we were representing, to ask them why they want to participate, what mattered to them. Now, on top of the list was the search for the truth. I want the judges to know what happened to me. I want the crimes not to be repeated. On the below part of the list was I want reparation. So actually, out of a little bit more than 30,000 people we were interviewed, I would say maybe the 3-5% wanted to participate because they want reparation. And also interesting, there is a distinction between victims who suffer what I could call economic crimes, pillaging, looting, destruction of properties, and victims who suffer crimes of rape, gender crimes, recruitment into the militia. For the victims who suffer the economic type of crime, it's easy for them to tell, well, I want my house back. I want my land back. So they can put a figure to the reparations. The others inevitably will tell you, well, my life was ruined. I'm not anymore a human being. I lost my dignity. Nobody can repair that. So the only thing that maybe the court can do is just to help me to turn the page, to rebuild somehow my life, to give to me some medical or psychological attention that could help me in rebuilding some kind of life. So the issue of reparation is a big issue because it differs a lot from person to person. And it's also a big issue because, unfortunately, the resources of the court are very limited. So it will be impossible for the court to compensate, for instance, cash the high number of victims participating in the proceedings. And in my experience, the majority of the victims expect more a sort of a collective reparation with an individual component. What does it mean? It means, for instance, thinking of programs of education, vocational training, which will be for a community, but targeted to the specific individual needs of each of the victims who eventually will be awarded reparations.
Paolina, thank you very much. I think we consumed our time for our session, but it has been an honor and unspeakable, unthinkable to express how valuable it is to be with you in this session. So thank you very much for attending to this festival, and I hope we will have other chances to meet again. Thank you.
Thank you very much, and it was my pleasure. I love speaking about victims because to some extent it's still an unknown territory and it deserves some attention. So thank you very much, and looking forward to the next festival, hopefully in person.